In the year of our Lord 1783, when the young American Republic was still catching its first, slightly ragged breath, a breath often choked on the dust and mud of truly atrocious roads, a different kind of revolution was quietly being incubated across the Atlantic, in the ancient, often waterlogged soil of Scotland. This revolution was not born of cannon smoke or political fire, but of gravel, geometry, and a grudging respect for the relentless persistence of water. To understand the legal history of the Macadam Road, you must first understand the ground upon which that history was written. Forget for a moment the stern-faced men in powdered wigs drafting statutes and arguing precedents. Close your eyes and picture, instead, the Parish Road, circa 1750. It is a road less traveled, perhaps, but certainly felt. It is a dark, churning waterway of viscous brown slurry in winter and a rock-hard, rutted washboard of cracked clay in the summer heat. This road was not merely an inconvenience, it was a profound daily economic and legal impediment. Every shipment of goods, every stagecoach journey, every doctor's frantic house call was a negotiation, often a battle, with the elemental tyranny of the terrain. The common law, inherited by the American states and still reigning supreme in Britain, recognized the problem, but its solutions were crude, rooted in a medieval communal duty known as the Statute of Labor. This law, dating back to the 16th century, dictated that every able-bodied man in a parish was obligated to contribute a certain number of days, usually 6, of unpaid, back-breaking labor to maintain the local roads. Now, imagine the efficacy of this system. Picture Farmer Giles reluctantly pulling himself away from his wheat harvest, showing up with his most ancient shovel and his least enthusiastic disposition. He is supervised by a parish surveyor, often an unpaid, amateur position held by an elected official who knew more about sheep than civil engineering. The result was predictable. A patchy, superficial, and fundamentally flawed repair job that often involves simply dumping large, unsorted stones, known as pitching, into the deepest ruts. These large stones quickly worked their way to the surface, creating a new, equally treacherous hazard for carriage wheels and horse hooves. The legal obligation was fulfilled, the practical problem was not. This inherent failure of the communal duty system became the very crucible for the Macadam method, not just as a feat of engineering, but as a legal and legislative necessity. The cost of poor roads was simply too high for a burgeoning industrial society. It was measured in broken axles, spoiled produce, delayed mails, and, most importantly for the legal mind, in endless, petty, and often ruinous lawsuits filed over damages, trespass, and the failure of contractual delivery times. The stage was set for a quiet, unassuming protagonist, John Loudon McAdam. He was not a lawyer nor a politician, but a Scottish surveyor who had spent nearly 2 decades in the United States managing his family's import-export business in New York. Crucially, he had witnessed the American struggle with vast distances and poor infrastructure firsthand. Upon returning to Britain in 1783, he settled in Ayrshire, Scotland. While the American legal landscape was crafting a constitution, McAdam was quietly performing road-related forensics across his county. His genius was not in inventing the road, but in understanding drainage and material science in a way that had legal ramifications. His core realization was simple, yet revolutionary. It is the native soil which ultimately sustains the traffic. The stone is placed merely to protect the soil from the moisture. This quote is an unspoken legal argument. If the road's foundation, the soil, is the ultimate support, then the failure to properly protect that foundation from water is negligence. McAdam's method, which would eventually bear his name, involved 3 radical departures from the common law's haphazard approach to road repair, and each departure necessitated a new legal framework for its implementation. Uniform material size. The stone used must be broken down into pieces small enough to pass through a 2-inch ring. small enough, Macadam famously observed, to not fit in a man's mouth. This required contracts and quality control, a legal shift away from whatever stones Farmer Giles could find. A raised, convex cross-section. The road must be built with a gentle curve or camber to shed water instantly to the side ditches. This demanded land rights and surveying precision, raising issues of property boundaries and drainage easements. Thorough drainage. The ground beneath the road must be kept dry at all costs. This meant managing adjacent land and water flow, leading to disputes over culverts and ditch maintenance. These requirements, quality materials, professional supervision, and a clear maintenance schedule could not be achieved under the ancient compulsory and fundamentally amateur statute of labor. The Macadam system demanded a professionalized, funded, and legally enforceable organizational structure. And that, my dear listener, is where the story truly shifts from engineering to jurisprudence, from mud to money and legislation. The Macadam era was ushered in by the Turnpike Trusts. These were not government bodies, but corporations, authorized by specific acts of Parliament to raise capital, build and maintain sections of road, and, most controversially, charge tolls, the infamous pike that turned or opened to let traffic pass. These trusts were the first real legal answer to the problem of road quality. They represented a move from the ancient, localized duty of the parish to a modern, centralized, and financially accountable system. Each Turnpike Trust Act was, in essence, a complex piece of private law, a contract between the government and a group of investors. The legal questions that immediately arose were staggering, and they set the tone for infrastructure law that would eventually be imported to and adapted by the American states. Eminent domain, or compulsory purchase. How much land can the trust legally take from a private landowner to straighten a road or dig a necessary ditch? What is just compensation? This legal battle over land rights became a recurring theme, often pitting the common good against the sacred rights of property owners. The power to levy a tax, toll. On what basis can a private entity charge the public for use of a public thoroughfare? What exemptions should be made? Farmers hauling manure? Clergy? Military traffic? The toll gate became a nexus of legal challenge and public resentment, forcing legislative refinement. Liability and maintenance. If a macadam road fails, or if an improperly placed stone damages a carriage, is the trust liable? This opened up new areas of tort law, specifically regarding corporate accountability for infrastructure failure. Macadam himself, having been appointed Surveyor General of the Bristol roads in 1815, became more than an engineer. He became a legal advocate. He testified before multiple parliamentary committees in the 1810s, patiently explaining his system, not just as a method of laying stone, but as a philosophy of public service and fiscal responsibility. His testimony was instrumental in guiding the creation of new laws, like the General Turnpike Acts of the 1820s, which sought to harmonize the thousands of local turnpike acts under a single, coherent national framework. He was in effect laying down the legal specifications for road construction that future courts would be called upon to enforce. This period, stretching from the late 18th century through the 1830s, is the golden age of Macadam jurisprudence. It is a quiet, steady flow of lawmaking that defines the public easement, the right of the public to pass over private land, and establishes the precedent that the state, or its delegated agent, the Turnpike Trust, has the right and the duty to manage infrastructure for the common good, even if it infringes on localized property rights. The legal battles were often fought in the chilly, dimly lit rooms of the quarter sessions courts, not on murders or high treason, but over the seemingly mundane. A ditch dug too close to a hedge, a toll collector's incorrect fare, or a misplaced heap of road-making stone left obstructing the way.
Chapter 2. The Tyranny of the Toll Gate and the Rise of Corporate Liability. As we settle back into the rhythmic narrative of history, we turn our attention from the engineer's treatise to the lawyer's brief. The Macadam Road, as established, required money, and the legal mechanism for raising that money was the toll gate. The toll gate was more than just a wooden barrier. It was the physical and legal embodiment of the Turnpike Trusts' authority. It stood as a daily, tangible confrontation between the collective need for better roads and the individual's desire for unburdened passage. And where there is confrontation, there are legal challenges. The early 19th century courts, both in Britain and later in the burgeoning American legal system, were flooded with disputes concerning these toll gates. These cases weren't about grand constitutional law. They were about highly specific, localized conflicts that illuminate the fine print of infrastructure legislation. Consider the complexity of exemption clauses. Every Turnpike Act, and later every state road law, included provisions exempting certain types of traffic from paying the toll. These were often rooted in economic necessity and tradition. Agricultural exemption. Farmers moving manure to fertilize their fields were often exempt, as were carts carrying materials to mend the local parish roads. This led to endless litigation about the definition of manure. Was it merely straw? Did it have to be actively decomposing? Toll collectors, always under pressure to maximize revenue, would often detain farmers, leading to charges of wrongful detention and trespassing. The clerical and military passage. Clergymen traveling to perform their duties and soldiers on active march were universally exempt. The legal question often revolved around proof of purpose. Could a clergyman traveling in a comfortable, four-wheeled carriage be genuinely said to be on duty, or was he enjoying leisure? The burden of proof in these minor toll disputes became a critical area of case law. The sheer volume of these cases forced Parliament and state legislatures in the U.S. to draft increasingly precise, almost exhaustively detailed statutes attempting to define every conceivable scenario, from the width of the carriage wheel to the type of cargo. This effort to legislate the details of everyday travel laid the foundation for the complex, hyper-specific nature of modern transportation codes. The more profound legal impact of the Turnpike Trusts, however, lay in establishing the principle of corporate liability for public works. Before the trusts, poor road maintenance was generally seen as a civic failing, a lapse in communal duty, often addressed by fines against the parish or surveyor. But the trusts were private corporations, established for the public good, but motivated by private profit, or at least return on investment. If a Macadam road was built poorly, or if the trust failed to maintain the crucial drainage that defined the Macadam method, and a traveler was injured or their goods were ruined, who was responsible? The landmark cases of this era generally upheld that the Turnpike Trust, by accepting the legislative mandate and the right to collect tolls, also accepted a corresponding duty of care to the public traveling. This was a critical legal step. It meant that negligence was actionable. A trust could be sued for misfeasance or nonfeasance, failing to perform a legal duty. If the surveyor allowed the stones to become too large, or if the ditches became blocked, causing the Macadam layer to fail, the trust could be held liable for damages. The duty was non-delegable. The trust could not simply blame a hired contractor. The ultimate responsibility for maintaining the road to the legal standards set out in the Enabling Act rested with the corporation itself. This concept of non-delegable public duty became a cornerstone of modern public works law. Imagine the quiet courtroom, the plaintiff, a merchant, whose wagon wheel shattered on a particularly sharp, exposed piece of stone, one that clearly did not meet the 2-inch standard set by Macadam's engineering and implicitly the trust's duty. The defense argues that heavy rain caused the damage, an act of God. The judge, referencing the Macadam method, calmly instructs the jury that the very purpose of a macadam road is to mitigate the effects of rain. The failure to drain properly is a failure of engineering, which in this context becomes a failure of law. This established a profound legal precedent. Good engineering is a legal defense. Bad engineering is a cause for liability. The quiet wisdom of John Loudon McAdam, his insistence on proper drainage and uniform stone size, was now woven into the fabric of jurisprudence.
Chapter 3. Across the Atlantic, the American Adaptation and the Federal Question. While the British system was struggling with the practicalities of private turnpikes, the young United States faced an infinitely greater challenge: scale. The American need for reliable transport was not just economic, it was existential. How could a vast, disparate union of states hold together without reliable routes for commerce, defense, and communication? The Roman Empire had solved this with military might and centralized planning. The Americans, steeped in Jeffersonian democracy and suspicion of centralized power, sought a different legal solution. The Macadam method and the Turnpike Trust model crossed the Atlantic quickly, primarily through publications and the efforts of figures like Henry Clay, who championed the American system, which included federal support for internal improvements. However, the legal framework had to be subtly but profoundly adapted for the American context. State charters, not parliamentary acts. Instead of individual acts of parliament, American turnpike trusts were chartered by individual state legislatures. This meant the quality and specifics of the charter and the corresponding legal duties varied wildly from New York to Pennsylvania to Virginia. The power of eminent domain, the legal right to take private land for public use, enshrined in the Fifth Amendment, nor shall private property be taken for public use without just compensation, became the greatest legal obstacle and generator of case law. Disputes over the valuation of land for road widening were constant. The legal phrase, just compensation, was refined and defined largely through early land condemnation cases involving turnpikes and canals. The federal road question, the most significant legal hurdle, was the debate over federal funding. Could Congress constitutionally appropriate funds to build roads within a state? The famous legal debates surrounding the Cumberland Road or National Road were not about engineering, they were about constitutional law. Presidents like James Madison and James Monroe vetoed bills for federal road construction, arguing that without a specific constitutional amendment, using federal funds for internal improvements was an overreach of power. This legal hesitancy meant that for decades, American macadam roads were built piecemeal, largely by private, state-chartered companies. It was the legal absence of a unified federal road policy that made the macadam engineering method a localized, state-by-state affair. But it also forced a more robust development of state-level corporate and property law. Every macadam road built in the early American Republic, from the Lancaster Turnpike in Pennsylvania to the local county roads attempting to emulate the improved system, was a document written in stone and statute, a legal acknowledgement of the public's easement rights and the corporation's duties. Chapter 4. The Quiet Legal Demise of the Turnpike Trust. The reign of the Turnpike Trust, that unique blend of private capital and public duty that built the early macadam roads, was surprisingly short-lived, legally speaking. By the mid to late 19th century in the United States and slightly earlier in Great Britain, the entire structure began to crumble under the weight of its own legal and economic contradictions. The primary legal issue was simple. The contract was fulfilled. The original legislative acts that chartered these trusts often included clauses, sometimes explicit and sometimes implied, that defined the term of the agreement.
The trust was typically authorized to collect tolls until its debt was retired and a fair return was made to its shareholders, or simply until a set number of years had passed. Once those conditions were met, the road was legally supposed to revert to the public domain, becoming a free road. However, the legal death of the turnpike was rarely neat or simple. Trusts, loath to surrender a steady stream of toll revenue, often employed every legal maneuver possible to argue that their original debt had not been retired, or that the constant need for maintenance, especially the rigorous maintenance required by the Macadam method, justified continuous toll collection. This led to a new wave of legal challenges, this time aimed not at challenging the tolls, but at challenging the very existence of the trust itself. The injunction and the writ of quo warranto. Dissatisfied citizens, often led by municipalities or rival business interests, began to petition courts for writs of quo warranto, Latin for by what warrant or authority. This ancient legal tool forced the Turnpike Corporation to publicly demonstrate the legal basis for its continued operation. This placed the burden of proof squarely on the trust to open its financial books and prove it had not exceeded the terms of its original state charter. The problem of obsolescence and neglect. As competing technologies emerged, most notably the railroad, many turnpike trusts saw their revenue plummet. Legally, however, they retained the duty of care for the road. Many trusts, facing bankruptcy, simply stopped maintaining the roads. They failed to relay the Macadam stone, they allowed the crucial ditches to become choked, and the quality of the highway rapidly declined. This nonfeasance, the failure to act, resulted in successful lawsuits against the trusts for negligence, driving their final economic stake. The courts, increasingly swayed by the public interest argument that major roads should be free and publicly managed, began to rule against the struggling trusts, dissolving their charters or forcing them to sell their assets. Chapter 5. The Birth of the State Highway Department. The Macadam Road, now freed from the private toll collector, needed a new legal and administrative guardian. This guardian emerged in the late 19th and early 20th century as the State Highway Department or Commission. This was the single most important legal and institutional shift in American road history. This transition involved three key legal acts. 1. The legal centralization of responsibility. State legislatures passed laws that formally transferred responsibility for the former turnpikes and increasingly for all major county roads to a new, centralized, state-level body. This was not a small change. It was a fundamental shift from highly localized, fragmented governance, the parish, county, trust, to state control over long-distance routes. This new body had a defined legal mandate that the Turnpike Trusts never fully achieved. Taxation, not tolls. It was funded by general taxation and eventually by specific taxes like vehicle registration fees and the gas tax, establishing the legal precedent that road funding should be tied to road usage. Standardization and enforcement. It was legally obligated to enforce uniform engineering standards across the state, ensuring that the Macadam method or its successors was applied consistently. This created the specification contract, where detailed engineering drawings became legally binding documents. 2. The legal embrace of professionalism. The State Highway Department was staffed by professional civil engineers, removing the political and amateur element that plagued both the old Statute of Labor and many of the early underfunded trusts. This professionalization had a legal benefit. It significantly reduced successful negligence suits against the state, as the courts afforded a greater presumption of competence to professional engineers acting under statutory authority. 3. Defining the good roads movement in law. The final factor was the good roads movement, which, while a popular and political movement, required legal codification. With the rise of the automobile and vehicle that absolutely demanded smooth, well-maintained macadam or paved surfaces, the public pressure for high-quality roads was overwhelming. State laws began to incorporate the language of good roads, tying the construction budget not just to maintenance, but to continuous improvement. Macadam roads, while revolutionary in 1800, were now legally recognized as being inadequate for the speeds and weights of the new motoring era. The legal transition was complete. The Macadam Road had begun as a private investment requiring a public toll, and it ended as a public utility funded by public taxation and governed by professional state authority. The legal principles that governed its construction, eminent domain, duty of care, and corporate/state liability, were now cemented into the foundation of modern infrastructure law, ready to handle the next great engineering challenge, the asphalt and concrete of the 20th century highway.
Chapter 6: The Constitutional Battle for Federal Roads. For the first century of American existence, the legal responsibility for roads rested firmly with the states, counties, and private turnpike companies. The shadow of the Constitution, specifically the debate over the extent of federal power, had always loomed large, effectively limiting Congress's ability to fund or build infrastructure within state borders. Presidents from James Madison to Franklin Pierce consistently argued that without a specific amendment, federal road construction constituted an overreach, touching upon the sacred realm of states' rights. This legal roadblock meant that even as the macadam technique was perfected, its implementation was geographically uneven and lacked coordination. You might enjoy a perfect, well-drained macadam surface for 10 miles, only to have it abruptly revert to a muddy wagon track at the county line, a physical manifestation of legal fragmentation. The economic and military needs of the nation, however, did not heed constitutional niceties. The arguments for federal involvement intensified, culminating in the progressive era of the early 20th century, a time characterized by a legal and political push for efficiency, standardization, and centralized planning. The legal shift from post roads to general welfare. The constitutional justification for federal involvement finally coalesced around two main legal powers granted to Congress: the Commerce Clause, the power to regulate commerce among the several states. As roads were undeniably necessary for interstate commerce, Congress argued that their improvement and regulation fell within this broad power. The Post Roads Clause, the power to establish post offices and post roads. While initially interpreted narrowly, this clause was expanded to justify federal interest in the routes used for communication. The rise of the automobile, however, was the true legal catalyst. The car was not a local phenomenon. It demanded national connectivity. It was impossible for 50 different, often antagonistic state and county commissions to build a coherent system. The Macadam Road, or its improved version, tar-bound macadam, or tarmac, was seen as the technical solution. The legal solution came in 1916. Chapter 7: The Federal Aid Road Act of 1916, Macadam Goes National. The Federal Aid Road Act of 1916 stands as the single most critical piece of legislation in American road history. It was the moment that the federal government legally and financially committed itself to creating a national highway system, thereby formalizing the Macadam Road's legal legacy. Critically, the act was a brilliant piece of constitutional compromise. It did not authorize the federal government to seize land and build roads directly, which would have drawn certain veto and legal challenge. Instead, it established a legal mechanism known as federal aid. Financial leverage. The act appropriated $75 million, a colossal sum at the time, to be distributed to states on a matching basis. The federal government would pay up to 50% of the cost of construction. The strings attached, legal mandates.
To receive the funds, the states had to meet two crucial legal prerequisites. They had to establish a state highway department that was legally competent to survey, construct, and maintain roads. This instantly forced every state to adopt the professional, centralized structure pioneered in the Macadam era, as discussed in Chapter 5. The roads built with federal money had to be maintained to the satisfaction of the Secretary of Agriculture, who oversaw the roads program. If a state failed to maintain the road, allowing the macadam surface to deteriorate, the federal government had the legal right to stop all future funding. This system effectively federalized road standards without federalizing ownership. The law enshrined the necessity of good, durable engineering, the very core of the Macadam principle, as a national legal mandate. The federal government, through financial authority, could now legally enforce construction quality and proper drainage, ensuring that Macadam's engineering philosophy was applied uniformly across the nation. The Federal Aid Road Act was the final legal chapter in the story of macadamization. It transitioned the road system from a collection of private legal contracts, turnpikes, and local duties, parish, into a unified national legal partnership between the state and federal governments designed to serve interstate commerce and the general welfare. It was the culmination of a century of slow, incremental legal debates about land, liability, and the duty of the governing body to build a lasting path.
Chapter 8. The Enduring Legal Legacy of the Macadam Road. The Macadam Road itself, layers of broken stone compacted and crowned for drainage, was eventually surpassed by more durable petroleum-based surfaces like asphalt concrete. Yet the legal framework that the Macadam era forced into existence remains the bedrock of modern infrastructure law in the United States and globally. The significance of the Macadam Road is not found in the material, but in the precedents it established. 1. The codified duty of care. The most profound legacy is the non-negotiable duty of care owed by the governing authority, whether a private turnpike trust or a state highway department, to the traveling public. Before Macadam, road failure was a regrettable local inconvenience. After Macadam, road failure became a legal liability. This principle means that today, every state and municipal department of transportation operates under the legal mandate to not only build, but properly maintain the roadway. The courts enforce this duty through tort law, allowing citizens to sue the government for negligence if a road defect, a poorly filled pothole, a failure to replace deteriorated pavement, or, tracing back to Macadam, a failure to manage drainage, causes injury. The standard of reasonable engineering, first established by Macadam, became the legal standard of care. The second point is the refinement of eminent domain. The Macadam era, particularly the establishment of the Turnpike Trusts, spurred the vast majority of the early American case law defining the Fifth Amendment's clause, "Nor shall private property be taken for public use without just compensation." Every time a modern highway is built, widened, or rerouted, the legal process of land condemnation used to acquire the necessary right-of-way flows directly from the countless small-scale legal battles fought by turnpike companies and state surveyors over a few feet of farmers' land for a ditch or curve correction. The courts of the 19th century, in adjudicating disputes over Macadam's requirements, defined the very legal mechanism by which the public interest can take precedence over private property rights, provided the compensation is fair. 3. The Blueprint for Public-Private Partnerships, or P3s. Although the original Turnpike Trusts failed, their legal structure, a private entity operating a public asset under a highly regulated government contract, was the first widespread American example of a public-private partnership. When modern states debate leasing toll roads or building major new infrastructure projects using private finance, they are legally and politically revisiting the framework first established by those early companies who built the first Macadam surfaces. The key issues remain the same: risk allocation, liability, and the term of the tolling agreement.
In the end, the Macadam Road was far more than gravel and stone. It was a catalyst that shifted Anglo-American law from a medieval system of communal labor to a modern professionalized system of corporate and government responsibility. It established the legal parameters for who pays, who builds, and who is liable for the paths that connect us. And with that, the long, winding, and sometimes muddy legal history of the Macadam Road comes to a restful conclusion.